Today we're going to talk about the law of search and seizure. So a search occurs when police intrude on a suspect's reasonable expectation of privacy. And a seizure occurs when the police interfere with the suspect's possessory rights to property. All right, search and seizure. Search when police intrude on a person's reasonable expectation of privacy. A search is when a person interferes with that suspect's right to certain properties. Okay, so the pinnacle case in this area is Katz versus the United States. All right, in the Katz versus the United States, it had kind of expanded this concept of privacy. So the Supreme Court held that a person who enters a telephone booth, right, that's outdated now, we don't have telephone booths anymore, and closes the door, shutting out that world, has a reasonable expectation that that conversation will be kept private, and that expectation is protected by the Fourth Amendment. Okay, so if you have a reasonable expectation of privacy, this person in this case had a reasonable expectation of privacy by shutting the phone booth door. And if you intrude on that, then you violated that person's Fourth Amendment rights. Okay, the Supreme Court, like I said, broadened the definition, right? Search occurs when police intrude on that person's reasonable expectation of privacy. The key word here is reasonable. All right. An illegal search occurs when police intrude on a suspect's reasonable expectation of privacy by, number one, physically trespassing into constitutionally protected area, so a home, for instance, or intruding into matters a suspect reasonably expects are private. Okay, emails. You may reasonably expect them to be private. All right, so you can physically trespass or intrude on matters that a person reasonably suspects are private. So the term person, for search purposes, encompasses those parts of the suspect's body and clothing that are not exposed to the public. Okay? Pockets are not exposed to the public. All right? It encompasses private parts of an anatomy, biological material, pockets, and undergarments. Right? So you can't search those, right? For a person, that's part of the person themselves, right? Private parts of an anatomy, biological materials, pockets, and undergarments. All right. Therefore, examining private parts of a suspect's body or clothing for evidence of a crime constitutes a search and requires Fourth Amendment search authority. Okay, you can't do it just because you want to. It has to be authorized per the Fourth Amendment. The term house or homes for search purposes includes the home and the surrounding buffer zone, known as, in legal terms, as the curtilage. So it includes apartments, hotel rooms, private offices, warehouses, telephone booths, like we said, and fixtures like cabinets and lockers. All right. Premise, structure, or fixture in which a person reasonably expects to have privacy. All right. So your home, it's the home plus the curtilage around the home. If you own an apartment, it's your apartment. If you're in a hotel room, that's yours. Private offices, right? So these are terms, homes that are protected by the Fourth Amendment, and in order to do that, you need some kind of authority to breach that. Papers includes letters, journals, records, films, or other private documents, right? And personal effects, your cell phone, your computer, tablets, handbags, briefcases, packages, anything, luggages, and other closed containers, right? These are considered effects. So all of these are protected by the Fourth Amendment. All right, so you have to understand it needs to be protected by the Fourth Amendment, right? If it's not protected by the Fourth Amendment, then you can search, all right? Search conducted by private parties without police complicity are not regulated by the Fourth Amendment, all right? All right, police may use evidence received from a private person without concern for how it is obtained. All right, so that's the interesting thing about this. If it's a private home, if it's a private club, there's no Fourth Amendment protection. And anything gathered during that can be used and no warrant is necessary. All right, you may use that evidence received from that private individual regards to how it was obtained. All right, police investigations without invading privacy include matters in open view. All right, this is the plain view doctrine. Police are free to make the same observation that members of the public can make. Okay, it's not regarded as a search because you have no reasonable expectation of privacy. Looking through a window, looking through open curtains, right? You don't have a reasonable expectation of privacy. You left the windows open. It's a plain view doctrine. All right, undraped windows. Not holes in fences. Garbage is on sidewalk. Garbage on sidewalk is considered in plain view. All right. You cannot encroach upon the curtilage of the home to peek into a window. All right, but from the street, you look through that undraped window. Okay. All right. You can use different things, right? You can use your flashlight. You can use binoculars, telescopes, helicopters. You can use your own senses, smell and hearing. Right? That is all not considered privacy, right? If you're looking through binoculars and you see something, okay, well, it's still in plain view, even though you're elevating how you view it. It's still not a violation of someone's Fourth Amendment right. Same thing with canine inspections. All right, in United States versus Place, the Supreme Court ruled that the use of a trained narcotic dog, detection dogs, to sniff luggage is not a search because it does not require opening the luggage or exposing its content. All right, once that happens, that's a different story. But the use of a trained narcotic dog to sniff luggage is not a search because it does not require opening the luggage or exposing its content, right? So canines can inspect at airports, bus terminals, train stations, even on the streets, in parking lots, and even in hotel corridors. And that's all considered fine, all right? It's all considered not a violation of someone's Fourth Amendment rights. All right, canine inspections may also be used during routine traffic stops. All right, as long as it doesn't extend the duration of the stop, okay, and the dog does not enter the interior of the automobile. Those two things are a violation, right? So if you extended stop, again, that's per statute, per state, on how long, what is it considered reasonable duration for a stop, and the dog cannot enter the interior of the automobile. Okay, abandoned property, right? That's a person who consciously and intentionally abandons property. They voluntarily relinquish any reasonable expectation of privacy in that property. Perfect example is garbage left on curb, right? You consciously and intentionally leave your garbage on the curb. You bring it to the curb. You intentionally leave it there. You voluntarily relinquish any expectation of privacy that you would have in that property. You put it on the curb. All right. And that's kind of a brief summary of search and seizure. The next video we're going to get into a little bit more detail, but figure to keep it short as an introduction for today. Thank you.